welcome everyone. My name is Stefan Solomon. I'm an assistant professor at the European Studies Department at the University of Amsterdam. And together with my colleague Liz Kula-Madail, I am co-hosting and organizing this conversation series on racism and law in Europe. The purpose of this series is basically to inquire into how law does not only respond to racial discrimination, but how also law might facilitate and is complicit in upholding forms of structural racism. Liz and I kind of like set up this series to address the absence in both legal academia and legal profession of a discourse of this relation between law on the one hand and racism and structural racism on the other hand. In particular, an absence of this discourse in continental Europe. In the Anglo-American context, this conversation has been more present, which is precisely where Shreya, our guest speaker today, is based at. Without further ado, Liz, would you mind introducing Shreya?
No. Well, thank you, Stefan. So yeah, it's a great pleasure to have Professor Shreya Atrey with us today, who's a professor of human rights at Oxford University and the author of a book entitled Intersectional Discrimination that was published with OUP in 2019. She's also an editor of the Human Rights Law Review and has just published an article in Current Legal Problems on racism and racial discrimination, arguing for a structural view, which will also be the basis for her presentation today. Shreya, welcome. It's lovely to have you here with us. So my first question to kind of get us started is an observation which sets up your current legal problems paper, namely that there is a case law around racial discrimination that finds that this racial discrimination occurs in the absence of racism. So I was wondering whether you could explain the rationale behind such case law.
Thanks so much, Liz, and thank you, Stefan. First of all, thanks so much for the invitation and thanks so much for organizing this series. I mean, there's really a dearth of conversation, not just in continental Europe, but I would think also, if you would rather include the Isles, in both the UK as well as Ireland, there's real absence of, I think, thinking through the relationships between race, racism, law, especially anti-discrimination law. So I think those links need to be investigated, and what better place to do that than this sort of a forum, which really speaks to sort of different kinds of contexts. So last month when you hosted Matthias Marschall, and he was talking about his work in continental Europe, I think it connects rather well to what's happening in the UK and also in Ireland. So I think this format, which sort of marries different kinds of contexts and tries to make sense of them one after the other, is a really good one for this conversation. So thank you so much. Liz, you asked about this counterintuitive observation that I make in my paper, that at least in the UK, discrimination lawyers seem to have found for race discrimination or racial discrimination in the absence of racism, that strikes as counterintuitive. That sounds almost bizarre. And I think the reason that it sounds bizarre has something to do with how we normally understand racism/racial discrimination. So if you look at the European jurisprudence, say take the European Court of Human Rights and its jurisprudence under Article 14, which is the right to equality, you would see that much of the work which has been done on racial discrimination, so discrimination on the grounds of racial and ethnic origin, that body of jurisprudence seems to use the word racism and racial discrimination interchangeably. So the assumption around discrimination law is generally that, well, racism and racial discrimination are kind of the same thing. And the UK's position, where there seems to be this delinking of racial discrimination from racism, seems to be an outlier. Now, where is this coming from? Where's this counterintuitive position coming from? So there's a lot much more case law that I could refer to, but perhaps the paradigmatic example of this was the first decision that was given by the UK Supreme Court. The first ever decision as the Supreme Court was actually a racial discrimination decision, which was given in 2009. This was the case of R and JFS. This was a case concerning a school having discriminated against students who were Jewish but did not follow the matrilineal line of descent and hence were not admitted to the school. The school was charged of racial discrimination. The court found for racial discrimination. But what's interesting in that judgment is that at 4 different places, the UK Supreme Court is hard pressed to remind us that although they have found for racial discrimination, that is not equivalent to racism. That even if the school had been guilty of racial discrimination under the race discrimination statute, it had not committed racism, and that the school was not racist. The reason for that seems to be that racism in the UK context, but also in the wider European context, has been understood as only having to do with the subjective state of mind, which is bigoted in nature. So unless you seem to have outright, downright, very explicit racist views which pit one racial group as superior in relation to others, nothing else seems to be qualifying as racism for the purposes of discrimination law. This view is central to both how UK discrimination law is organized, but also how the European jurisprudence is organized. What that leads to is a denial of racism in a broader sense. What I mean by that is that by taking racism as highly individualized in nature, you're negating the possibility that racism may be something broader, not to do with individuals, but with structures per se. So I wanted to make that argument, but I had to sort of start off by showing why is this argument important, and what do I have to do to actually make this argument. So what I wanted to show was that you in fact have to negate the view that racism is simply about individual bad apples in the society. But I had to sort of displace that view from the doctrine, from the actual jurisprudence. And I thought it was a good starting point to show that in fact judges themselves have delinked racism from racial discrimination by taking this very narrow view of racism. But the moment you sort of broaden that view out to include structural racism, you in fact can see the connection between racial discrimination and structural racism in a broader sense. Now, what I don't want to claim is that racism is equal to racial discrimination and that there's no difference between the two. So take a pick, see any discrimination legislation which defines racial discrimination. Take CERD, the UN Convention on Elimination of All Forms of Racial Discrimination. Take the EU Race Directive. Take the UK Equality Act 2010. None of them seem to equate racism with racial discrimination. And I think the reason for that is that there are differences. And those differences matter, at least for my purpose, as a discrimination law, in terms of how we establish racial discrimination, right? So there's usefulness in keeping the two categories as separate in terms of making racial discrimination not just easier to prove, but having a template which is easier for lawyers to follow in terms of having a clear sense of not having to deal with subjective state of minds, which is relevant to perhaps racism. But I think that understanding of racism in itself is very narrow for discrimination lawyers. Here's one more interesting thing, and I'll end with this observation. Discrimination law seems to have developed from the tort law model to think about whether there is there's liability, whether there was a duty, whether that's been breached, and then to impose some kind of remedies. But when it comes to thinking about racial discrimination, we somehow need to switch gears and come to the criminal law mode of thinking, where it's all about mens rea. You're thinking about, did the person really want to do this? And those patterns of thinking about racial discrimination, I think equating racial discrimination with racism in this narrow sense as having to do with subjective state of minds, really makes short of what racism is as a category, and then dealings both racism and racial discrimination. So those were some of the things that I was trying to draw out in making this claim that in fact racism and racial discrimination are linked, although they might not be the same thing.
May I jump in there and ask you another question, because I found it so interesting, kind of like reading that in your article. And when you kind of like listen to the reactions of, say, even police authorities, even here in the Netherlands, kind of like who were frequently accused of racial profiling, the reaction of police authorities was, well, these are actually some individual bad apples, some individual bad cops who have their own kind of like subjective state of minds, and therefore perform and kind of like perform racial discriminatory profiling, which kind of like points to the view that conventionally kind of you could say racial discrimination is considered as individual aberrations of from kind of like a general norm of a prohibition of discrimination, and therefore as non-structural. You in your article, however, make the kind of like the counterintuitive observation or argument that, well, what we should actually look at when we consider racial discrimination is to take a structural perspective on racial discrimination. So can you explain us what you mean by a structural view or perspective, and where this concept of a structural perspective actually comes from?
Thanks, Stefan. So this structural view of racism comes from the wider social sciences literature that I rely on, and I find that very helpful as a discrimination lawyer, because unlike other fields where the subject of a particular law is really defined by law, so say contract law deals with contract, and that's a legal fiction that has been created. It has very specific counters in law because it's a legal instrument. Discrimination is not a legal thing per se. It exists out there. And I think social sciences literature really helps us sink our teeth into what is the social reality of discrimination. So as a discrimination lawyer, I find reference to political theory, anthropologies, sociology, even economics of race discrimination vital to understanding what racial discrimination is. So the structural view comes from there, and it refers to what John Solomos would say is the complex totality of, I'm really sorry, I have somebody at the door. Give me 1 second.
Well, those are the perks of the online setting.
Sorry, Stefan. Exactly.
Welcome back, Shreya. No worries at all.
Now I was just thinking you were right in saying it might have been better to be in the same room, so no one would come knocking at the door. So I wanted to say something about what the structural view is. I just said that the structural view comes from social sciences literature, in particular political theory, and I'm drawing on John Solomos, David Goldberg, who think that the structural view really is about taking a complex view of the totality of forces which shape racial relationships between people in the society. So social, political, cultural, economic relationships between people, the way they have been shaped, if you consider them in totality, you would come to something like a structural view. There are two things which are quite specific about the structural view when compared with the individualistic view of racial discrimination / racism having to do with individuals per se. One is that the structural view is political in nature. So at the top, it is concerned with the states, especially modern states, in the way that they are ideated, that is imagined, in the way that they function, in terms of how they govern, and in terms of how both their imagination and their governance is experienced by the people. Right? So if you take a structural view, you're really trying to see how the society as a whole is organized, and who is organizing that society at the broadest level? It's the state. Right? So you take the widest, broadest view out, rather than focusing at the bottom of the pyramid at individuals, you look at those at the top, and that's the state. What has the state done in terms of defining those social, cultural, political, economic relationships between people? That's what structural view is interested in. The second thing which is critical about the structural view is that it's interested in processes of racialization rather than racism per se. Now, racism in the narrow sense is not entirely helpful for understanding structural view, but what is helpful is thinking about what are the different processes through which hierarchy is attached to people, right? So whether it's through the instrumentality of law, whether it's through economic policy, what exactly is happening which pits people against one another and arranges them in a hierarchical order such that some racial and ethnic groups are above in that rank order. That's the process of racialization, and that's what the structural view is interested in. So both the political focus, the focus on modern states and how they are imagined, how they govern, how their effects are realized by people, as well as the focus on processes of racialism or racialization, which tell the more complex total story of what goes on when people are put in this hierarchical rank order in the society. Both of these make up the structural view.
Okay. That's so interesting. And to be honest, Shreya, it was only in your article that I fully understood sort of the literature as it becomes relevant for legal practice. So this is exactly where I would like to go next, namely to the practical implications of taking such a structural view. Could you give us some examples of that for direct and indirect discrimination?
Thanks, Liz. So the structural view remains largely absent in racial discrimination law. So the law which prohibits racial discrimination doesn't quite take the structural view. And my purpose with this work has been to show that it doesn't matter whether lawyers, judges have taken this view. You can actually see the structural view as explaining some of the cases which are out there. And I think a good example of both direct discrimination and indirect discrimination as infiltrated with this structural view is the hostile environment policy in the UK. So for those of you who might be aware, and for those who may not be, since almost the last 10 years when the Conservative Party, the Tory government, has been in power, there have been a series of legislative and policy changes which come under this umbrella of hostile environment policy, which have been brought forth as making it difficult for people who are non-white to be in this country. And the rationale for that has been that it's directed towards those who are illegally present. So what can be done for those who are illegally present to find it difficult to continue to stay? If they cannot be found out that easily, let's just make it hostile for them to stay in this country. And some of those policies, for example, in the Immigration Act 2016 as amended, one of them is that there's a new criminal provision which has been created, which is driving while being illegally present in the UK. Now, the way that you're picked for driving while you're illegally in the UK is that it's often that this kind of policy runs along color lines, along belonging to a different ethnic origin, or wearing something which looks non-traditional from the European perspective, right? So some of the racial / ethnic / cultural markers lead to people being picked out. Now, the statistics on this are that non-white people are twice as likely to be picked for this offense and to be stopped in their vehicles as compared to white persons. So it's not necessarily that you're particularly targeting those present illegally in the UK. You might just be targeting those who are very well present in the UK legally, but happen to be non-white, either national citizens or those generally legally present as migrants. That law seems to have race as almost encoded into it, because the way it's going to be enforced seems to run along racial, color, ethnic lines. There's almost no other way of enforcing, of stopping someone than having to rely on race, color, ethnicity per se. My interpretation of this kind of law is that it's not necessarily that this is a neutral law which is being applied to non-white persons or the BME or the BAME population, but this is in fact a law which has race encoded and hence should be seen as a case of direct discrimination. That is, discrimination which treats people less favorably on the grounds of racial or ethnic origin. In a very similar case, you can see indirect discrimination as transpiring as part of the hostile environment policy. So Immigration Act 2014 introduced a duty on landlords to make checks to inquire whether somebody who's renting from them has a right to actually be in that country. That has led to landlords necessarily asking for people to prove whether they actually have lawful permission to stay in the UK, whether to either show passports or resident cards or visas, by relying again on color, ethnic origin, the sound of people's names, the way people look. And again, all of these seem to run on what we broadly call racial lines, where you perceive people as belonging to a different nationality, a different ethnic group, having different color than you, dressing differently, having a different name than standard English names, for example. So all of those lead to landlords having to enforce this law and effectively being border police in enforcing this law. And that has been challenged in the UK courts, and the challenge is slowly moving towards the appeal. And it seems that what's gone on in that case is that there's a bar to understanding this kind of a hostile environment policy in structural terms, to see that it's the state which has imagined itself as closed off to immigration and to immigration from certain kinds of people. So and those often happen to be people of color, and that legislation's it seems that it's not looked at from a structural perspective, because state itself is seen as not having that view, right? So there's no way to penetrate the reasons behind the state as having legislated such a policy in the first place. So it's very difficult in discrimination law to look at what's going on, because there's an assumption that that you don't inquire into intentions of the legislation, but but the structural view cannot be activated unless you look into the politics of why certain laws are framed, and to look behind the reasons for them having the kind of discriminatory impact that the hostile environment policy does. So I think the hostile environment policy generally is a very good example of both direct and indirect discrimination cases. And they seem to show that unless we pierce the veil of neutrality of the state, that it's the state is not involved in processes of racialization, and really upturn the assumption that in fact it is the state at the top which racializes through its laws, through the instrumentality of the justice system, including the operation of discrimination law, that it's through these processes that racialization is taking place. We cannot quite get to grips with either addressing racial discrimination effectively or addressing racism effectively.